Justice Barrett's icy mockery of Attorney General Pam Bondi in a heated Supreme Court clash sparks a stunning comeback that shakes the courtroom and leaves the nation riveted. In the hallowed chambers of the Supreme Court, tension crackled like static before a storm. The case of Meridian Industries versus the Department of Labor had drawn a packed gallery, with legal scholars, reporters, and spectators leaning forward in their seats. At the center of it all stood United States Attorney General Pam Bondi, her posture resolute, her eyes scanning the 9 justices perched above. Across from her, the Department of Labor's counsel fidgeted, sensing the weight of the moment. But it was Justice Amy Coney Barrett, known for her sharp intellect and unflinching commitment to textualism, who would ignite the fuse. Bondi stepped to the podium, her voice steady as she began her argument. Meridian Industries, a manufacturing giant, had challenged a Department of Labor regulation mandating costly workplace safety measures, claiming it overstepped constitutional bounds. Bondi argued that the regulation lacked clear statutory authority, violating the separation of powers. She cited the major questions doctrine, asserting that such sweeping economic impacts required explicit congressional approval. Her delivery was crisp, her reasoning rooted in precedent, but the air shifted when Barrett leaned forward, her expression a mix of skepticism and amusement. "Ms. Bondi," Barrett interjected, her tone clipped, "you rely heavily on this so-called major questions doctrine, yet your citations feel more like a wish list than a constitutional anchor. Where, precisely, is the precedent that ties this doctrine to your client's case?" A murmur rippled through the courtroom. Barrett's words carried a sting, her faint smile suggesting she viewed Bondi's argument as flimsy, perhaps even amateurish. The other justices exchanged glances, some nodding subtly, others scribbling notes. For a moment Bondi stood silent, the weight of Barrett's challenge hanging heavy. But Bondi was no novice. A former prosecutor with decades of courtroom battles. Behind her, she had anticipated this moment. Her team had spent months dissecting every angle of the case, poring over Barrett's own judicial opinions and academic writings. She straightened, her gaze locking onto Barrett's. "Justice Barrett, with respect, the precedent is robust and directly applicable," she began, her voice calm but edged with steel. She rattled off a string of cases: West Virginia versus EPA, NFIB versus OSHA, each a pillar of the major questions doctrine, each delivered with surgical precision. The gallery stirred, sensing a shift. Barrett's smile faded, her pen pausing mid-note. Bondi pressed on, her argument gaining momentum. She quoted a 2018 Law Review article Barrett herself had authored, which emphasized the judiciary's role in checking agency overreach. "As you wrote, Justice Barrett, courts must ensure agencies act within the bounds of delegated authority, lest they usurp Congress's role. This regulation does exactly that." The courtroom fell silent, the air thick with anticipation. Bondi had not only countered Barrett's jab but turned it back on her, wielding the justice's own words as a weapon. Chief Justice Roberts raised an eyebrow, while Justice Kavanaugh leaned forward, scribbling furiously. Barrett's face remained composed, but her eyes betrayed a flicker of surprise, perhaps even unease. Bondi's preparation was undeniable, her command of the law formidable. Yet Barrett was not one to yield easily. She adjusted her glasses, her voice now measured. "Ms. Bondi, you've cited my work, but you've yet to address the textual basis for your claim. The statute's language is broad. Why should we read it as narrowly as you propose?" The question was a lifeline for the Department of Labor, a chance to regain ground. Bondi paused, her mind racing. She knew the next few minutes could define the case, and her legacy. Every eye in the room was on her, waiting to see if she could match Barrett's challenge or crumble under the pressure. As she opened her mouth to respond, the courtroom seemed to hold its breath, the stakes higher than ever. Pam Bondi stood at the podium, the Supreme Court's silence pressing against her like a physical force. Justice Barrett's question about the statute's broad language hung in the air, a calculated challenge meant to expose any weakness in Bondi's argument. The Department of Labor's counsel, sensing an opening, shifted in his seat, ready to capitalize if Bondi faltered. But Bondi's pause was not hesitation. It was the calm before a storm. Her eyes, sharp and unyielding, met Barrett's, and she began to speak, her voice cutting through the tension with surgical clarity. Justice Barrett, the statute's language may appear broad at first glance, but its context and history demand a narrower reading, Bondi said, her tone measured, yet forceful. She launched into a meticulous dissection of the Occupational Safety and Health Act, the statute at the heart of the case. Line by line, she traced its legislative history, citing congressional debates from 1970 that emphasized limited agency power. Congress intended OSHA to address specific workplace hazards, not to issue sweeping mandates that reshape entire industries, she argued, her words punctuated by the faint scratch of justices' pens. Barrett's expression remained impassive, but her fingers tightened around her pen, a subtle sign of engagement. Bondi pressed her advantage, pivoting to the text itself. The statute uses the term standards, not regulations. Standards imply targeted evidence-based measures, not the kind of blanket economic overhaul the Department of Labor seeks. She cited a 1980 case, Industrial Union Department versus American Petroleum Institute, where the court struck down an overbroad OSHA rule. The court has long held that vague statutory language does not grant agencies a blank check, she said, her voice rising slightly, daring Barrett to disagree. The gallery buzzed softly, reporters scribbling furiously. Justice Gorsuch, known for his textualist leanings, nodded almost imperceptibly, while Justice Kagan leaned back, her eyes narrowing as she weighed Bondi's logic. But Barrett was not done. She leaned forward, her voice now carrying a sharper edge. Ms. Bondi, you're asking us to impose a limit Congress did not explicitly write. Isn't that judicial overreach? The very thing you claim to oppose? The question was a trap, designed to paint Bondi's argument as hypocritical, and it landed like a grenade in the courtroom. Bondi's jaw tightened, but her composure held. She had prepared for this, knowing Barrett's knack for turning arguments back on their makers. With respect, Justice Barrett, it's not overreach to enforce the Constitution's boundaries, she countered. The non-delegation doctrine exists to prevent Congress from abdicating its authority. If we allow agencies to exploit vague language, we erode the democratic process. She quoted Barrett's own dissent in a 2021 case where the justice had warned against unbridled agency power. The audacity of the move drew gasps from the gallery. Bondi was not just answering, she was schooling Barrett with her own words. Barrett's face flushed slightly, a rare crack in her judicial armor. Chief Justice Roberts intervened, his voice calm but firm. Ms. Bondi, let's focus on the practical. Your client claims this regulation imposes undue costs. Where's the evidence? The question shifted the battlefield, forcing Bondi to pivot from legal theory to economic reality. She welcomed it. Meridian Industries faces a $2 billion compliance burden, threatening thousands of jobs, she said, citing a detailed economic study her team had submitted. This isn't speculation, it's math. The Department of Labor's counsel, sensing his moment, rose to object, arguing the study was biased. The exchange grew heated, voices overlapping until Roberts banged his gavel. The courtroom stilled, but the tension was electric. Bondi had held her ground, but Barrett's eyes were locked on her, calculating, unyielding. As Bondi prepared to address Roberts' question further, a new challenge loomed. Could she tie her economic argument back to the Constitution without losing the court's conservative wing? The echo of Chief Justice Roberts' gavel lingered. In the Supreme Court chamber, a stark reminder of the razor-thin line Pam Bondi walked. The Department of Labor's counsel, still standing, had just challenged the economic study Bondi cited, his voice dripping with accusation, as he labeled it industry-funded propaganda. The gallery shifted, sensing blood in the water. Justice. Barrett's gaze, unrelenting, bore into Bondi, her earlier flush replaced by a steely resolve that seemed to dare Bondi to falter. The question from Roberts, demanding evidence of the regulation's burden, hung like a guillotine, and Bondi knew she had to weave her economic argument back to constitutional principles to hold the court's conservative justices. Bondi exhaled, her mind a whirlwind of strategy. She turned to Roberts, her voice steady despite the pressure. "Mr. Chief Justice, the economic impact is not merely a number. It's a constitutional red flag. When a regulation imposes costs that threaten an industry's survival, it triggers a scrutiny under the major questions doctrine." She pivoted to address Barrett directly, sensing the justice's skepticism. "Justice Barrett, your own writings underscore that agencies cannot wield transformative power without clear congressional intent. Meridian's $2 billion burden isn't just a hardship, it's evidence of agency overreach." Barrett's lips pursed, but she didn't interrupt. Bondi pressed on, citing the court's 2022 ruling in Alabama Association of Realtors versus HHS, where an agency's economic overreach was struck down. The Department of Labor's regulation reshapes the manufacturing sector without a single line of statutory text authorizing it, she said, her tone sharpening. "This isn't regulation, it's legislation by unelected bureaucrats." The words landed hard, drawing nods from Justices Gorsuch and Alito, both staunch defenders of the non-delegation doctrine. The Department of Labor's counsel, a wiry man named Daniel Weiss, couldn't stay silent. "Objection, Your Honors," he interjected, his voice tight. "Ms. Bondi mischaracterizes the regulation. It's a targeted safety measure, not a sector-wide overhaul." He gestured to a thick brief on his table. "Our data shows minimal economic impact. Meridian's study inflates costs to scare the court." The accusation was bold, and Weiss's eyes flicked to Barrett, hoping to rekindle her earlier skepticism. Bondi didn't flinch. "Mr. Weiss's data comes from the same agency pushing this regulation," she shot back, her voice laced with controlled indignation. "It's like letting the fox guard the henhouse." The gallery stirred, a few spectators whispering. Bondi turned back to the justices, her focus laser-sharp. "Meridian's study was independently verified by economists at Stanford and MIT. It's not bias, it's reality." She laid out the numbers. 15,000 jobs at risk, 200 plants facing closure. The human cost was palpable, and Justice Kavanaugh, usually reserved, scribbled intently. Barrett, however, was unmoved. She leaned forward, her voice low but piercing. "Ms. Bondi, you speak of costs, but what of the workers this regulation protects? Are their lives not a constitutional concern?" The question was a masterstroke, forcing Bondi to balance economic arguments against human stakes. The room felt smaller, the air heavier. Bondi knew a misstep could alienate the court's moderates, who valued pragmatism over ideology. She took a breath, her response measured. "Justice Barrett, worker safety is paramount, but this regulation's one-size-fits-all approach harms more than it helps. Meridian's own safety protocols exceed OSHA's standards, yet they're penalized with crippling costs." She cited a 2019 case, Kaiser versus Wilkie, where the court warned against rigid agency rules. "The Constitution demands precision, not blunt instruments." Barrett's eyes narrowed, but she didn't counter. A small victory, but fleeting. Weiss seized the moment, rising again. "Your Honors, Ms. Bondi cherry-picks facts to dodge the statute's clear intent." His tone was aggressive, almost personal. Roberts raised a hand, but before he could speak, Justice Thomas, silent until now, leaned forward, his deep voice cutting through. "Ms. Bondi, Explain why this regulation fails the textualist test. The room froze. Thomas's rare question was a lifeline and a challenge. Could Bondi deliver an answer that would sway even the court's most enigmatic justice? Justice Thomas's voice, low and deliberate, sliced through the Supreme Court's charged atmosphere, silencing Daniel Weiss's aggressive jab at Pam Bondi. The Department of Labor's counsel froze mid-sentence, his accusation that Bondi cherry-picked facts left dangling. All eyes turned to Bondi, standing resolute at the podium, her pulse quickening under the weight of Thomas's question. His rare intervention was a beacon for the court's textualists, and Bondi knew her answer could tip the scales, or unravel, her case. Justice Barrett, still smarting from Bondi's earlier use of her own writings, watched with a gaze that could cut glass, while Chief Justice Roberts settled back, content to let the moment unfold. The gallery held its breath, the tension so thick it seemed to hum. Bondi met Thomas's steady stare, her voice clear and unwavering. Justice Thomas, the regulation fails the textualist test because it stretches the Occupational Safety and Health Act beyond its plain meaning. She zeroed in on the statute's key phrase, standards reasonably necessary or appropriate. Textualism demands we read these words as they were understood in 1970, she said, her tone methodical, yet forceful. Congress used standards to mean specific, evidence-based measures, not sprawling mandates that burden entire industries. She cited the Act's legislative history, quoting a senator who warned against overzealous agency power. The precision of her argument drew a subtle nod from Thomas, a rare sign of engagement. Weiss, visibly rattled, tried to interject. Your Honors, the statute's text is flexible by design. But Roberts cut him off with a sharp glance. Bondi seized the opening, pivoting to a 2001 case, Whitman versus American Trucking Associations, where the court rejected an agency's attempt to expand vague statutory language. The court has consistently held that agencies cannot rewrite statutes under the guise of interpretation, she said, her voice rising with conviction. This regulation does exactly that, imposing costs Congress never authorized. Justices Gorsuch and Alito leaned forward, their pens moving swiftly, while Kavanaugh's eyes flicked between Bondi and Barrett. Barrett, however, was not ready to concede. She leaned forward, her voice measured but laced with challenge. Ms. Bondi, you insist on a narrow reading, but the statute's purpose was to protect workers. Why should we ignore that intent? The question was a gauntlet, testing Bondi's ability to reconcile textualism with real-world consequences. The gallery stirred, sensing the stakes. Bondi's earlier success had rattled Barrett, and now the justice was pushing back, determined to expose any flaw. Bondi didn't hesitate. Justice Barrett, textualism doesn't ignore purpose. It respects Congress's chosen means to achieve it. The Act's purpose is worker safety, but its text limits how OSHA can act. She cited Meridian's voluntary safety measures, which reduced workplace injuries by 40%. This regulation doesn't enhance safety. It punishes companies already doing better than required. Her words were a direct challenge to Barrett's question, framed in the justice's own textualist language. Barrett's jaw tightened, but she didn't respond, a silence that spoke volumes. Weiss, desperate to regain ground, rose again. Your Honors, Ms. Bondi's textualism is a smokescreen to shield corporate profits. His voice cracked with frustration, drawing a murmur from the gallery. Bondi turned to face him, her expression calm but her eyes blazing. Mr. Weiss, the Constitution isn't a suggestion. It binds agencies as much as it binds this court. The retort was swift, and Weiss sank back, his face reddening. Justice Kagan, usually a skeptic of anti-agency arguments, raised an eyebrow, intrigued by Bondi's tenacity. But the clock was ticking. Bondi's time at the podium was nearly up, and she hadn't yet addressed a lingering concern. The regulations' impact on small businesses, a point Justice Sotomayor had raised earlier. As she prepared to pivot, Barrett interjected again, her voice now icy. "Ms. Bondi, you've danced around the human cost. How do you justify prioritizing industry over lives?" The question was a trap, designed to paint Bondi as callous. With seconds left, Bondi faced a defining moment. Could she answer Barrett's challenge without losing the court's moral center? Justice Barrett's icy question hung in the Supreme Court chamber, a final salvo aimed at unraveling Pam Bondi's case. The accusation that she prioritized industry over lives stung, and with her time at the podium dwindling, Bondi felt the weight of every gaze in the room. Justice Sotomayor's earlier concern about small businesses lingered unanswered, and Daniel Weiss, the Department of Labor's counsel, smirked faintly, sensing a crack in Bondi's armor. But Bondi, forged in decades of courtroom battles, saw the trap for what it was. She straightened, her voice steady, her eyes locked on Barrett's. This was her moment to seal the case and silence her doubters. "Justice Barrett," Bondi began, her tone calm but resolute, "I don't prioritize industry over lives. I defend the Constitution's limits to protect both." The gallery leaned forward, captivated. This regulation doesn't just burden giants like Meridian, it crushes small businesses, the backbone of our economy. Addressing Sotomayor's concern, she cited a study showing 60% of small manufacturers faced closure under the regulation's costs. These are family-owned firms employing thousands. Their workers lose jobs, not safety, when businesses collapse. Her words were a direct rebuttal to Barrett's charge, blending moral weight with economic reality. Barrett's expression softened, but she didn't interrupt. Bondi pressed on, tying her argument back to textualism. The Occupational Safety and Health Act demands reasonably necessary standards. This regulation fails that test, harming more lives than it saves. She quoted Barrett's own 2020 opinion in Bostock versus Clayton County, where the justice emphasized precise, statutory interpretation. "As you wrote, Justice Barrett, courts must follow the text, not rewrite it to serve broad goals. This court honors lives by honoring the law." The echo of Barrett's words was deliberate, and a flicker of recognition crossed the justice's face. Weiss rose, his voice sharp. "Your Honors, Ms. Bondi's sob story ignores the regulation's life-saving intent." But his interruption faltered under Bondi's glare. "Mr. Weiss, intent doesn't trump the Constitution," she shot back. "This regulation's overreach violates the separation of powers, a principle this court has upheld for centuries." Chief Justice Roberts nodded subtly, while Justice Thomas, ever stoic, scribbled a note. The tide was turning. With seconds left, Bondi delivered her closing blow. "Meridian's safety record proves businesses can protect workers without agency overreach. The Constitution demands Congress, not OSHA, write laws this sweeping." Her voice rang with conviction, and as she stepped back, the gallery erupted in whispers. Barrett's pen lay still, her earlier skepticism replaced by a thoughtful frown. The oral arguments ended, but the confrontation's impact was just beginning. Weeks later, the court's ruling stunned the legal world, 6-3 in favor of Meridian Industries, striking down the regulation. Barrett, in a concurring opinion, echoed Bondi's arguments, emphasizing textualism and the major questions doctrine. "Agencies must act within clear statutory bounds," she wrote, a nod to Bondi's relentless advocacy. The opinion was a triumph, but whispers spread that Barrett had been visibly shaken during deliberations, her initial mockery of Bondi replaced by respect. The media frenzy was immediate. Headlines blared, "Bondi's brilliance humbles supreme court." Legal scholars dissected the exchange, calling it a masterclass in advocacy. Bondi's citation of Barrett's own words became a case study in law schools, a testament to preparation meeting opportunity. The ruling reshaped agency power, reinforcing constitutional limits, while small businesses hailed Bondi as a champion. In private, Barrett confided to a clerk that Bondi's argument had forced her to confront her own principles, a rare moment of vulnerability. As Bondi left the court that day, reporters swarmed, but she offered only a smile. She had faced the highest authority in the land and prevailed, not with bluster, but with unyielding precision. The showdown was over, and Pam Bondi had emerged not just victorious, but legendary, her legacy etched in the annals of legal history.